Welcome to The Point of View. This is your favorite current affairs show here on Channel 1 Television. On The Point of View, we pick the right topics, we get the right guests, and ask them relevant questions on issues that matter to you. We have a huge show for you because it's been a very important week legally, constitutionally, democratically for Ghana. We've had almost 5 major issues after the Akonta mining judgment of Chairman Wontumi. We've had the OSP's constitutionality cemented by the Supreme Court. We've also had some very far-reaching conclusions on how political parties are to choose their representatives. We hadn't finished discussing that, then we had the acquittal of the former CEO of Maslock, Sedina Judgement, and then the big one, the government's position paper on the Constitutional Review Committee has also come out. We don't have all the time in the world to delve into that, but I have 3 of the sharpest minds in studio tonight to discuss at least 2 of those 5 issues. Stay with us.
Why? What's wrong?
Introducing Ghana's leading pay-as-you-copy photocopier leasing company. Lease an A4, A3, heavy-duty or production machine and pay for only the copies made or design your own payment plan. Simple and tietia. That's not all. Incredibly, toners, repairs, maintenance, follow-me printing, centralized tracking all come free of charge. Remember, financial prudence is the name of the game. Folks, forget about the expensive gimmicks and be smart. Join the hundreds of satisfied clients across all the 16 regions and every sector of the economy and save over 60% of your printing costs. Visit us at www.valixlease.com or call 0244 644048. Be prudent and lease a copier. Terms and conditions apply. Valix Lease is a wholly owned Ghanaian company. Valix Lease, affordable document management solutions.
Hey, who's the person that is here? And somebody
Big game today as Ghana faces England.
You forgot the eggs.
And the whole nation is ready. Shot on target. Oh, what a save! Benjamin Asari flying for Ghana.
What is it? Politics is always safe.
Every day, in the moments we love, we rely on clean and safe water that flows from Polytank.
So these are very interesting times if you are a student of democracy, a student of the Constitution, a student of law, or simply a student of journalism, because we have 2 massive matters to discuss tonight. Sedina Judgement has been a big bombshell. Many reactions coming through for that. After 3 days, people have reflected, and it appears the views are a bit more sedated. We'll deal with that. We'll also delve into the government's position paper on at least 130 proposals that the Constitutional Review Committee put out. So who do I have in studio? We have Nana J. Bafwe, who is MP for Menchia South. Are you the Otun Force MP?
I'm the Otun Force MP.
Wow, in all your glory. That's wonderful. Do you come here with his permission and his blessings?
Well, so long as he elected me to go to Parliament.
Amazing. So in a sense, you have a lot of power. And yet you're also very powerless. We'll deal with that later. Welcome. Thanks for coming.
Thank you.
Again. We have a man who's been pushing the envelopes of the legal discussion in this country, Oliver Bakavomawo. Okay, I think his work with Democracy Hub is more useful in these conversations, right? You've done many things in your life.
Yes.
So Democracy Hub, what's your role there?
Constitutional Rights and Policy Strategy Advisor.
Democracy Hub, wonderful. Welcome. And congratulations, because I think at least two of the cases have something to do with you. So congratulations on the OSP in particular, and we'll deal with that as well. And then we have our long-lost friend who I've brought back to this show. Alhaji Yusuf Hussaini is a former minister of a number of portfolios. He's also a lawyer and former MP for Tamale Central. I'd like to also commend him for endorsing the Northern Business Fair, which we did last weekend. Alhaji, welcome to the show.
Thank you. Thank you.
I didn't know you could drive a tractor. You were on a tractor last weekend.
If you are somebody who was born to a farmer, your father had a tractor when you were very young.
Wow.
At least curiosity will drive you to try your hands on a tractor. So I know how to operate a tractor.
Thank you for your support for the Northern Business Fair. Let me start with Bafo. So I've heard the two other guests in parts on the two issues we're discussing tonight. What was your initial reaction when you heard of the Court of Appeals acquittal and judge of Sedina? And now that you've read the judgment, how do you feel?
With the greatest of respect and humility, I think in many places the Court of Appeal was wrong, and I'll demonstrate that to you. I'd read the High Court judgment. I listened to many discussions, including my brother. Over the weekend, I was in Kumasi. I listened to him. The High Court judge, the Court of Appeal judges at many places were wrong. And I'll demonstrate that very respectfully with ease. The prosecution had discharged their burden. And the Court of Appeal judge focused too much on things the prosecution did not do, instead of evaluating the evidence before them and giving us the legal effect of what was before them.
Okay. I see.
Let me repeat it. They focused on things in their opinion the prosecution should have done, instead of evaluating what was before them and giving us their legal position or their legal consequence as far as the law of evidence was concerned. You see, an appeal is by way of rehearing. So you rehear the matter without the drama attendant with the High Court trial.
Okay.
At that stage, you have the benefit of the record from the High Court. And so you have to look at the evidence and look at the law, the elements of the criminal charge, and determine whether there is enough evidence on record based on the rules of evidence that satisfies the offense.
Okay.
And so, in my view, that was what they ought to have done. It is not what the Attorney General, right?
The prosecutors.
It's not what the prosecutors failed to do at that point. Tell us the effect necessarily. Let's take Obatampa.
The company that supposedly made those payments. And I'm jumping the summary because this is a developing story. So a lot of my viewers would have known the basic facts.
Sure.
So proceed.
So the prosecution had laid a charge of stealing, or had preferred the charge of stealing against Obatampa. There was no dispute that money had been transferred to Obatampa. There was no dispute before the court. What was in the contention was whether or not the money had gone to Sedina. And if the money had gone to Sedina, right, whether or not Sedina had the intention of appropriating the money or keeping it permanently for the purposes of your listeners, that she wanted to keep the money and make it hers. That was the contention. Indeed, in view of the disputed fact of whether or not the money had been returned to Sedina, right? If the case that the money had not been returned to Sedina is established, you don't need to go on to establish whether or not it's her intention to appropriate the money. But if you establish that indeed the money had been returned to her, then you have to go on to establish that it's her intention to keep the money permanently. Now, how did the prosecution move on to prove this? They called the witness from Obatampa, who comes to say, we delivered the money to her. Not just that, he gives you the location where the money was delivered to her. From the two judgments, the High Court judgment and the Court of Appeal judgment, there is no evidence of Sedina's lawyer during cross-examination challenging Obatampa.
On which fact? On
the fact of whether or not, on the fact of his claim that he returned the money to Sedina at Bachuda Tuta. What is the effect of this in law? The Court of Appeal did not discuss. It is very vital. The effect of this is an admissibility in law. When a crucial evidence is not challenged, it amounts to an admission. And so in going into the appeal, the fact which had been admitted was that the money was returned to Sedina. Unless you challenge this, without a challenge, that is the effect in law.
I see. So that's your first
That's
gap.
my first gap.
Because of time, I want you to be like bulleted.
My second gap is that Exhibit A was tendered as evidence of the return of the funds by Obatampa's representative.
Okay.
Right? That Exhibit A, the Court of Appeal sought to assail it by saying that on the strength of Sedina's statement to the police, it had been impugned. In other words, she has raised doubt about the Exhibit A. And therefore, the court should have done a better assessment of it. I think that the court misdirected itself on the position of the law. And that misdirection, which is an inconsistency, look, if you go through the judgment, that misdirection indeed becomes obvious. And I'll demonstrate to you. You see, Sedina had not gone into the witness box to testify. So the statement she gave to the police had not been tested. And you cannot use an unsworn and untested evidence to assail a tested evidence. How do you test evidence? You test evidence through cross-examination. That is when you test the veracity of the evidence. Sedina had not gone into the witness box, and so she had not been cross-examined. Her statement to the police had also not been cross-examined. How do you use an unsworn evidence, right, to impugn a sworn evidence? And he himself, the Court of Appeal judges themselves, right, contradicts themselves in this judgment. And I'll show you. Let's go.
So this is still on point 2.
This is
point 2B.
Point 2. This is point 2B.
Because I'm trying to get the logic of the specific things.
I'm coming to tell you.
So the Obatampa issue, no challenge.
So when you come to
and the exhibit tendered in, not cross-examined.
So when they were evaluating, when the court was evaluating,
this is the High Court or the
this is the Court of Appeal's decision.
Okay.
When the Court of Appeal was evaluating the charge of sensitization, right? One of the issues at hand was that the officers of the regional officers of Maslock had given Yoko a written statement, but they were not called to testify.
Okay.
And for that reason, the court deemed their written statement to be a hearsay and could not be relied upon.
Fair enough.
It is the same written statement which you relied on to impugn.
They talk about an Iyoko investigation.
Yes.
Which they called it.
Yes, but that is the written statement to the police. That is the statement I was giving to Iyoko. Sedina's statement was to the Iyoko, and that is the police.
But are you not forgetting that one person is alleging and one person is defending? So that if I'm a judge, and based on my non-law understanding of this, if somebody is saying that you are a thief and he presents evidence that you are a thief, he must prove beyond reasonable doubt that you are a thief. As against me saying I'm not a thief, I don't have to prove beyond reasonable doubt I'm not a thief, right? So I think that the understanding is that the Court of Appeal said the burden on the person alleging is stronger than the person defending.
It doesn't change anything. It doesn't change anything. What it means is that you produce evidence to prove your claim.
Beyond reasonable doubt.
Beyond reasonable doubt.
That this person has committed the offense.
Good. And what is the evidence provided in this matter? The evidence provided in this matter is that Obatampa people say they gave money to Sedina, 500,000, which was a refund or a return of money they had given.
Did they show evidence of giving the money beyond the assertion?
So you have to distinguish this. I think that we confuse something. Sometimes we make it seem as though oral evidence is not evidence. Oral evidence is evidence. It is when it is challenged that you need to provide more evidence to support or corroborate your position. Now, Obatampa, who had been given the money, came to testify that we have returned the money to Sedina.
All right.
That is evidence.
Did they provide anything to back
you
that
don't
claim?
need that until it becomes necessary. And this is where I say there is the misconception.
Fair enough.
Evidence is either oral testimony or material evidence, which is relevant to the issue which is being resolved by the court. And so in proof of your assertion or your case, you may call oral evidence or you may produce material evidence.
So the point is very clear. So you've done 10 minutes, by the way. So I'm keeping time. So can you make your final comment on the
So my point is that
Court of Appeal thing? Then
the prosecution proved this case by calling the very people who had returned the money to Sedina.
All right.
The prosecution proved this case by providing evidence, which is Exhibit A.
Okay.
Right? The judge misdirected itself, the Court of Appeal judges misdirected themselves when they used an unsworn testimony to impugn a sworn and tested evidence. An unsworn and untested evidence cannot be relied upon. And the Court of Appeal itself stated that in their, let me show you.
Are you suggesting that everybody who's defending themselves have to necessarily testify in a case against them?
Let me explain to you. You don't. But where it becomes necessary, you have to. And this is another misconception. In any matter, you have no obligation to defend yourself in court.
You can even decide to keep quiet.
You can even decide to keep quiet. But when the burden shifts, if you don't speak, it will be ruled against you.
So how do you tell me that the burden shifted?
When you produce sufficient evidence, and in this particular instance, it is my submission that sufficient evidence had been produced. And the court rather focused on what in their opinion ought to have been done, instead of evaluating what was before.
So
it.
essentially you agree with the High Court, you disagree with the Court of Appeal?
Yes. The court rather focused on what in their opinion should have been done by the prosecution.
So you're giving me 3 solid points. Let me take Alaji's view. You said somewhere that this...
If I may point... Please, Allah,
okay.
Let me point you to very.
I'm doing time.
I appreciate. You see, this thing. There's a lot of misconception going around.
Okay.
And because people are reading the judgment with all humility like a storybook.
Okay.
And so, because of how well structured the judgment is, you can easily be swayed. If you look at it very critically, evaluate it in accordance with the rules of evidence, you appreciate what we are saying.
Some people even think that rather the atmosphere had been poisoned by the fact that they were baying for blood, and therefore the Court of Appeal's judgment rather was met with a lot of anger because people who haven't even read the original judgment and the Court of Appeals judgment were feeling upset.
No, because people, you see, the truth of the matter is that people are aware of the manner in which this whole thing, the chronology, the sequence, people are aware. How does a criminal appeal ordinarily, if it wasn't for Sedina, how would it be done in less than 6 months? How do you go ahead to
the speed as well?
The speed. How do you even go ahead to hear a matter when the convict is not in the jurisdiction? Hear it. Is the hearing is different from the judgment.
So you're speaking about the speed as well, and also spoken about the not being. Okay, so therefore you've made 5 points.
Let me quickly refer you. I beg you.
Okay.
I'm begging you. You see, let's go to the sensitization bit where the judge made.
You've made a Batampa testimony point. You made Exhibit A point. You've made the standard of 2 testimonies not having been sworn. You've made the speed, unusual speed point, and you've just added a 5th point about not being in the jurisdiction. That's 5 points.
I want to add a legal position to it.
Okay.
From the same judgment.
Good.
From the same judgment, paragraph 86. By the operation of section 60 subsection 1 of NRCD 323, a witness must speak only to matters within their personal knowledge. Section defines hearsay evidence other than statement. Therefore, statement made outside the courtroom cannot be admitted as proof of their assertions. Witness statements given by an accused person or any other potential witness to the police is a statement made outside of the courtroom. It's made outside of the courtroom. It's not made inside the courtroom. When you go into the witness box, right, and you take an oath, you testify.
Yes, we understand this.
Good. Now, the statement by Sedina, right, the statement by Sedina to the police, which the judge relied on, had not been tested, was never tested. Because
you've made, and you're saying that, of course, neither was the Yoko statement also tested. So we understand
once you exclude, or
you should exclude. Well, fair enough. Alazi, thank you for your time. You said somewhere that this judgment was seminal in relation to the role of prosecutors in criminal trials. That's a very big thing to say.
Yes.
Because there have been some big cases. So there have been Atufosin, there have been a few others. In terms of Court of Appeals, why is this seminal?
It's seminal because it goes to the duty on the prosecutor in prosecuting a case. I mean, or let me put it in another way. The law imposes a duty on prosecutors, whose duty must be discharged at all times, whether the accused person is within jurisdiction, is outside jurisdiction, or simply refuses to talk.
Okay.
And that is improving the guilt of an accused person. The burden of proof is on the prosecution.
Okay.
The standard of proof is also on the prosecution, unless the offense is a strict liability offense, or in some cases, licensing offenses. Now, in licensing offenses, you can frame the charge in the negative. You are operating without a license. Now, because it's a licensing matter, licensing offense, and the ability to determine whether or not the accused person is operating within the law and has a license, he's given a license, so he produces the license. He discharges the burden that he's not, so that's where it shifts. Now, so in this case, when you read the judgment, and with the greatest respect to my colleague, lawyer, and member of parliament, I know that when the decision came, everybody, including myself, were confused. In fact, we were very emotional because we just calculated the time that a certain number was extradited from the United States to Ghana. And she had not even spent up to 3 months in jail, and she was walking away. But as a lawyer, I was sitting with very important, big people, educated people, and everybody was talking. They asked my opinion. I said, I can't give an opinion then.
You hadn't read the judgment.
I said, I'm also surprised. But this level of surprise can only be answered if you read the judgment.
Of course.
Because as a lawyer, I know, and all of us know, that when an appeal is filed, it goes through processes. Okay? So it is not the case that you file an appeal and hear it in 6 months. It's not the case. That's not the case. The appeal itself was filed on the 9th of May, 2024. After the appeal had been filed, records were settled. When the records are settled, and the registrar of a court will not settle records if the hearing notice for the settlement of record is not served. But if the hearing notice is served and there's proof of service and one party elects not to be present, the registrar will go ahead and settle the records. The records were transmitted. And so there are processes. And when you calculate the processes, that are involved in an appeal, you'll be left in no doubt that this appeal went through all those processes. Now, I want us to look at what the Court of Appeal is saying. It's saying that some of the charges were defective.
They said 34 were irredeemably
defective.
That's a very serious word. It says that they can't be saved.
And the court relied on the Ernest Thompson case.
Yeah.
And when the charges were defective, the court ruled that they were defective. So the Attorney General had to go back and redraft the charges. Okay? And Article 19 of the Constitution, which is part of the fundamental rights provisions, requires that you inform the accused person of the offense that he's been charged with, so that he or she has been charged with, so that person can prepare the defense. You can ambush the accused person in court and keep all the evidence, and then confront the accused person in court with evidence that he or she does not know about.
Okay.
But what is really disturbing in this case is that in 2 instances there were exculpatory evidence for Sedina. One is the Cantonment fire disaster. The investigator produced a report and indicated in the report that his investigations had established that the money had been paid out. Therefore, Awa and Co. did that.
Let me say.
No, please.
I'm not the bar.
Yes.
I'm not saying that you.
Yes.
But you're not an accountant.
Yes. But let me clear it.
Yes.
It's Patrick.
Yes.
Yes. People have been saying that
you are the guy.
I'm the guy. I'm not.
Yes.
I don't. If he's here,
So it's an accounting firm.
It's an accounting firm.
Yes. But I've never.
It's not even a
met
relative.
No.
So you are Nana Eje Bafwewa.
Yes.
And that's Bafwewa and associates.
It's possible we may be related, but I've never met him before.
It's important you make that point.
Bafwewa himself is a grown up man. He's not a young man.
But
Maybe
people don't know.
people doing it mischievously.
People don't
Proceed.
know.
Had done an audit of the activities of Sedina at Maslock and had cleared the payment.
Okay.
And that was known to the prosecution at the time that they were prosecuted. It was known. Thirdly, the successor of Sedina Temakulu gave evidence in court and said that they were no longer pursuing the Cantonment Market Fire case.
Okay.
That it was no longer relevant. These were the words Stephen Amwa used in court. But prosecution went ahead, charged her of the offense, and then the court convicted her on the offense in which exculpatory
provided.
evidence had been provided. So that is one. You see that the prosecution in the Sedinam case at the High Court appeared to be more interested in conviction rather than justice. Now, the second thing that baffled my mind was the car issue, the 61 million. You have Sedinam Temaklo is said to have committed the government of Ghana to a system 1 million deal, and that the cars had been delivered, and that the deal was tainted with fraud, illegality, because she had no authority so to do. The state decided to go ahead with the contract.
Okay.
Whoever gave Stephen Amwa the authority to renegotiate the contract, we are not told.
He's the CEO of Maslow who took over after Sedinam.
Sedinam. How much he renegotiated the contract, we don't know. How much the state paid for the renegotiated contracts, we don't know. But most importantly, we knew that, we all know now that Sedinam paid nothing.
She was not paying. She wasn't in office when the payments was made.
She didn't pay anything to.
Although the contract was signed in her time.
Yes, but she didn't pay.
But had you renegotiated?
Renegotiated. So when you renegotiate the contract, you
cannot be. You are saying you can't be convicted of a payment
that was made. A contract that was renegotiated.
Yeah.
So when you renegotiate a contract, to all intents and purposes, a new contract has come into being, and then you convict the outgoing CEO for committing Ghana to a payment.
Unless maybe the new CEO thought that her original contract was so badly signed and that locked us to the extent that he could only beat down the cost, but couldn't.
No, if the original contract was so bad, was so tainted, the option was there: repudiate liability. Simple. And that becomes your defense.
So if you've made two big points.
Third one.
Okay.
Sedina was paid ex gratia, not by herself, but her finance director, who was a prosecution witness, who came to court to testify that he paid Sedinam and the deputy the ex gratia.
Okay.
And the ex gratia was calculated based on documents. That is her appointment and terms and conditions of service, and other documents which were relevant for the calculation of the of Sedinam and her deputy's ex gratia, and said affirmatively, conclusively, that he authorized the payments. Sedinam was convicted on account of paying herself ex gratia when she had no lawful authority.
Okay. So what I've seen is you've pointed three holes in the original High Court judge's decision. And he's pointed some holes in the Court of Appeal decision. So I want to.
No, I'm just saying. I'm come out in the Court of Appeal.
I know. I'm summarizing what I've heard so far.
No,
unless you have one more point to add.
He's not holding the High Court judgment.
I have the High Court judgment here.
Yeah, so but he didn't refer to the High Court judgment.
So that's what I'm saying. So he's interested in the one he doesn't agree with. And you are interested in the one you don't agree with. So it's fine. So I wanted to take a breather. When I come back, I have a referee. So I asked him to just tell me what he thinks of the two angles to the discussion. So give me a minute. This is the point of view. Tonight we're doing two things. We're looking at the Court of Appeals discharge and acquittal of Sedina Temaklo, former CEO of Maslow. And then we'll also talk about the government's position paper on the Constitution review. Stay with us.
My line of work, a confident smile is everything. Kel Charcoal toothpaste keeps me on top of my game and ensures my smile is always radiant and bright.
With the tiring nature of my job, we spend several hours under the scorching sun. To keep our teeth white and our breath fresh all the time, we use none other than Kel Charcoal toothpaste. Kel Charcoal toothpaste. You're on a case and then a kit one.
Some of your candy need. And who be here, so make just a papa dear to a mammy man for Kel Chacos natural ingredients. And a bomb is civil buying, a man is swing, and the stars of Mamma Hotel, so it will beg you.
Kel Charcoal Toothpaste. Choose Kel Charcoal Toothpaste for anti-cavity, whiter teeth, and fresher breath all day. Available in 80 gram and 150 gram. Grab yours today.
Kel, happy smile. This advert is FDA approved.
Imagine a life where every moment flows effortlessly, where every choice brings you closer to the life you've always wanted. Give yourself more ways to receive joy. Have more time to party. With G-Money, every moment flows seamlessly. Just pay and keep the good vibes going. Instantly top up airtime or data so you never miss life's special moments, because your memories together should matter more. Give yourself more freedom to celebrate. Pay bills quickly and seamlessly so nothing disrupts your moments. Have more financial control. With G-Money, you can effortlessly manage bulk payments and keep your business running smoothly. Dial *488# or download the app and explore the new G-Money today. G-Money. Give yourself more.
Welcome back. So tonight, as you can see, we are trying to get different perspectives of the same matter. It appears to me Lawyer Bafwewa is not, or not appears very clear, he's not happy with the Court of Appeal's reasoning. He seems to agree with the Sewabuche's reasoning as the trial judge. The Inu Safuseni is more inclined to point gaps in the original conviction in agreeing with the arguments of the Court of Appeal. So Oliver, for this round, let me make you a referee. Also because you are part of the anti-corruption shouters, right? So do you agree that sometimes the way the matter is tried in the public domain and presented, extradition, sort of influences how the public receives without even necessarily reading the judgment, and therefore you could see a lot of disappointment? Do you agree with that and proceed from there?
I think that, you know, irrespective of whether or however one receives the Court of Appeal decision, the public have a right to be aggrieved by the entirety of the circumstances.
Okay.
Because there's still, you know, a large gap of information which is unaccounted for. There's some of them which is explained on the record, but there's also monies that we still don't know the truth of. That has not been established concretely. What we do know is that Maslog does not, it's 500,000, for instance, less than they have, and we don't know whether Obatampa has it or Sedina has it from the records before us. What we can say from what the Court of Appeal has said, and I agree with, is that there has not been a true showing on the record conclusively for anybody to determine that in fact the money went to her. That much I agree with. Now, in terms of, you know, something that Bafo is saying, and this much I concede, that when we are reading the judgment through the lens of the Court of Appeal, and even in terms of the High Court, a lot of the times what happens is that the judge focuses the entirety of the record on matters that they consider relevant, that makes their point. So we don't have the benefit of the entirety of the record to compare A to B. We're reading how they assess the evidence before them, what they find compelling, to determine whether we also find it compelling. When it goes, for instance, to the Supreme Court, they would also have to start from ground zero and take each one and see, okay, maybe there are even things on the record that we did not.
Because we don't found it relevant to put in the judgment.
We don't know that the court might look at again and consider differently. But on the point of the caution statement, the Court of Appeal referred to it as Exhibit AM. And if it has been exhibited, then it seems to me, even if the point is not made, that somebody must have tendered it in. And for which reason it forms part of the evidence to be considered. Okay? So I don't know for a fact in terms of how it became part of the record. On the question of the regional directors, there were no statements which were refused.
Okay.
The Yoko investigators said we spoke to the regional directors and they said X to us.
Okay.
And so the court said, but where are the original declarants? Because you're reporting it. So there's not like their statements were then introduced in the same way, for which reason it refused to consider those statements. So that's the only point I think perhaps we're disagreeing.
So maybe they feel the Yoko may have been paraphrasing. So we want to be clear who said it.
Exactly what was said.
I'll come back to you.
Okay. So that's kind of what perhaps my struggle on this matter is. But there's a bigger point, I think, in terms of our prosecution generally, perhaps that starts from Tetuchi Kata till now, that we seem not to still understand or figure how we can prosecute willfully causing financial loss to the state. It has been thrown out in Ernest Thompson, thrown out in Atuforsen, even in terms of Tetuchi Kata was eventually acquitted on the same thing. That there seems to be, and that's been my point, there's been a capacity deficit in terms of how we frame
Could the defect be in
charges.
The law?
And how we
could the defect be in the law itself?
I don't think that the law. I don't think the law is defective. I think that perhaps, for instance, you have 78 charges, and then you have a situation whereby, in terms of how and I've watched how prosecution prosecutes a lot of the time, you are not very clear if you're not careful which of the witnesses is speaking to which of the charges, because you have general statements that are made. Sometimes they're not particularly clear in setting out which witnesses are speaking to which of the charges. Particularly when you have 78 of them, and a lot of the time the serial, if I took 5 CD today, 2 CD tomorrow, 3 CD,
they serialize it.
They serialize it and create so many charges.
It makes it sensational.
It makes it, pretty sensational.
Yeah.
In the same regard. So for me, I think that's perhaps where the issues are. But I think the content of the law itself is not problematic. The example he gave, connection with the renegotiation of the contract, for instance. You cannot charge a person with causing financial loss to the state when you have taken steps to avert that loss being caused.
Particularly when it's willful. Don't forget that the adjective is willful.
Willful, right? So he had said something earlier, which I agree with, not here, that if she had been charged, for instance, with an attempt to, perhaps you could say that your original conduct could have resulted in X, but you failed to. But that we eventually, because failure for it to succeed is still a criminal offense, irrespective of what happens subsequently. So there's sometimes overcharging that respects, that results sometimes in some of the decisions that happen. But for me, I think that ultimately, when you read the judgment, based on what they rely on, there's significant soundness to it and what they eventually conclude, based on what they have.
You get the impression that because the public is baying for blood when it comes to corruption, prosecutors will work with indecent haste.
I think the problem is in insufficient conversations between prosecutors and investigators.
Okay.
So a lot of the times you would see, in many instances, certain charges are first preferred by the investigators because the Yoko itself will grab the people, and before you know, they have filed some charges in court and the questions of bail and whatever come in. Then you have a prosecutor that comes in. While there are already some charges before the court. Eventually, they might withdraw some and frame new ones. But the process of sitting down back and saying, okay, I don't know how we arrived at this, or we arrived at the second one, is oftentimes not very clear. I am a big fan of separation between the investigators and the prosecutors, and not, for instance, the Yoko arrangement, I'm not a big fan of, where they themselves are going to court to prosecute. You need an independent third party who the evidence is presented to
test it.
That must test it, read through it, and decide that, okay, based on what you have provided for me, these are the offenses I want to charge. And ask you, I think this is still missing from the record, what can you produce? And make the decision then to go forward. But if they themselves, with their own officers, from it, come back and then put it, it's like the police investigated and police prosecuted. They charge and then they stick to it and they go all the way without, in fact, doing that necessary work. So that's, for me, I think, where a lot of the deficiencies come up. But in particular, I think that there's more appetite to be a bit more literal and perhaps more extensively analytical when we have charged persons of high repute, as compared to when we have charged persons with no means. A lot of these pass. A lot of people are prosecuted.
The standards are very low.
The standards are lower. So, I mean, if you look at the fact that in terms of the conviction rate for unrepresented people in this country, it's almost near 100%.
A guy got 10 years for stealing a phone last month. He violently snatched a phone from someone and he got 10 years. And he hasn't even generated any discussion. A mobile phone.
So they're not represented.
But this is 10 years for some, of course. We are not saying we've proved this, but you're right. There appears to be, which means that the public conversation influences the process. Right?
No, I think it does. I won't be surprised that it does in many respects.
Let me give you a quick comeback.
So Bernard, in response to the defective charge,
Yeah.
the court again misdirected itself on the law.
Court of Appeal.
Court of Appeal, yes. Let's look at Section 31, subsection 2 of the Courts Act. The court shall dismiss the appeal if it considers that no substantial miscarriage of justice has actually occurred, or that the point raised in the appeal consists of a technicality or procedural error, or a defect in the charge or indictment, but that there is evidence to support the offense alleged in the statement of offense. Now, so the point is that...
Take note of it.
No, yes, that there is evidence to support it. The point is, because it was struck out as defective, the court did not even give itself the opportunity to analyze or evaluate the evidence.
The 34 of the 70.
Yes, to evaluate same to determine whether or not there is evidence to support them. Do you understand?
You are talking about the 34 that were considered defective.
That were considered defective. And so the court misdirected it.
But you consider it defective after evaluating it.
So
you don't say it's defective just from birth, right?
So wait, there are two things. Evaluating the charge as to whether or not it is defective. Evaluating the evidence on record, whether or not there's evidence to establish the charge. There are two different things. The law is that the charge, once there's evidence to support it, and there's no miscarriage of justice, right? You cannot say that because it's defective, you are striking them out.
But if the charge is effective, then the evidence doesn't
In fact,
arise.
let me give an example.
Wait.
Which is incapable of being supported by proof.
Okay.
It says, count 45. Conspiracy to commit crime, namely willfully causing financial loss to the state, contrary to section 23 and 179. Particulars. Sedina Christine Tamaklu Ationu, Daniel Axim, on or about 21st April 2016, in Accra, in the Greater Accra region, agreed to act together with a common purpose to willfully cause financial loss to the state. How much? What is the substance of the financial?
That's all.
That's all.
It doesn't explain anything.
It doesn't tell us what you are referring to.
So what does the law say?
No, but
wait.
What evidence are you going to
my brother.
Okay, you did that. This is 46. So what do you want to say there?
You see, law is not about emotions.
So this 46 that he just read.
So let's go through section 31 too. Let's take our time and read it.
Let's hear you.
The court shall dismiss the appeal if it considers that no substantial... So what is an appeal? You've appealed. The court dismisses it, which means that the court thinks that it finds no merit with it. Considers that no substantial miscarriage of justice has actually occurred.
Okay.
And so, or that the point raised in the appeal consists of a technicality or a procedural error or a defect in the charge or indictment, but that there is evidence to support the offense alleged in the statement of offense. The point is that it may be defective, but in the course of the trial, sufficient evidence has been introduced to support the fact that there has been you have willfully caused financial loss to the state. It doesn't matter whether or not it's defective, to the extent that there's no miscarriage of justice. And that is the point we need to add. This is statute.
But must I not? Let me ask. Must I not understand the offense you've charged me with for it to even merit evidence?
So that is why, if you're a lawyer in this matter, like it happened in the Ernest Thompson matter, you raise it from the very outset. If you sit down and the trial goes on, because especially in this era where there are disclosures.
So you are saying you should have gone for no case?
No. Challenge.
There's no estopel in criminal trials.
No, there's no estopel. There's no estopel. But the point is that you should have challenged it from the outset.
No, there's no estopel. That's why in the London bumping case, the people even served their sentence. Finished. The IRA case. And then when they came out, they went back to court and said that they were convicted wrongly, and the court acquitted them.
Wrong conviction. I don't know the facts in this matter. You are comparing apples with oranges. With the greatest of respect. I am speaking to a statute. So
if I understand, you're saying that the 34 charges that they say were irredeemably defective ought to still have been tested with the evidence adduced.
Exactly.
We shouldn't have just dismissed them on the face of the way the charge was presented.
Exactly.
Because maybe
it even makes it worse. Look, it's even worse this time. After the ex parte Dofor decision, where the court orders disclosures right ahead of the matter.
But let's stay with 46 that he read. So in the course of the case, was evidence adduced to prove that thing he just read?
I don't have the benefit of the record.
Okay.
So I caught one. I looked at it. I couldn't see how.
But
they just arrived at a convicting position.
I'm saying that it is. You see, this is where I was telling people over the weekend that.
How many minutes is he doing?
because
he doesn't want to stop.
This is where. Because you've been interrupting. It's your interruptions which is the problem.
Why for you on the floor? Go ahead.
You see, this is why I keep telling people that when you read a judgment, the person who did the matter or someone who has the benefit of the record is able to challenge it better. Because he knows what must have transpired in the courtroom. The judge's duty is to pick and choose which evidence, right, supports a certain course that he's taking.
Okay.
Somebody who has the benefit of the record would say that, look, you did not advert your mind to this evidence which was adduced in the matter.
Okay.
If you had adduced your mind to this evidence, you'd have come to a different conclusion. When you look at this law, it does not make a defective charge defective or a basis for dismissing an appeal simpliciter. That is a fact. That's the general position. Is that not the general? Are we agreeing that that's the general position?
No, we agreed.
You agree?
Yes.
Good. So if you agree that a charge which is defective does not ground a dismissal simpliciter, then what is the next step? The next step is that the reason why it does not ground a dismissal simpliciter is because the law allows the prosecution to lead evidence.
Correct.
And in leading evidence, it may be able to establish something. And I'm saying that it is even worse today in the light of the Supreme Court decision that makes or compels the Attorney General or the prosecutor to disclose documents or evidence ahead of the trial. Because at that point, you are seized.
The so-called disclosures.
The disclosures also furnishes you with certain information. And so in that regard, I think that the judge, the Court of Appeal judges, misdirected themselves. This is my position based on the law. And I'm happy that you have agreed to the general position.
Agreed to the general position.
No, I'm not. Let me respond to someone.
No, wait. Let me listen. We need to deal with this matter.
Let them respond when I'm done. Because they said
you are in threat of contempt.
No, please, Bernard.
Allow me.
Bernard, there are things they have said.
I'll come to you. Bernard,
there are things
he
they
needs to
have
respond
said.
to this point.
First of all, I think that he's totally misread the judgment. Totally.
I'm not.
Listen,
the law or the judgment?
The judgment.
The law or the judgment?
For this is not necessary. Let me listen to him.
So the grounds of appeal were up to I. The appeal court dismissed as defective charges that were contained in, the reliefs that were contained in B, C, D, E, F, G, H, which dealt with the defective nature of the judgments. Of the charges, and came under the omnibus clause. That is the conviction and sentence of the first accused appellant for the offense of conspiracy to stealing, conspiracy to cause financial loss to the state, causing financial loss to the state, causing loss to public property, improper payment of public funds, unauthorized commitment to, resulting in financial obligation to government, money laundering, and breach of Procurement Act is unreasonable and cannot be supported, having regard to the evidence on the record. That gave the appeal court an opportunity to evaluate all the evidence. All the evidence. That's why you will see, so if you are charged of causing financial loss of, stealing 1,700 and something that was meant for sensitization, and I say that the charge was defective, the appeal court says, if that charge, we have dismissed all, that relieves that, we have dismissed all. even though the charge was defective, but because of the omnibus provision, it gave them the opportunity to assess the evidence. That's why you can read, and then you will see that every charge is covered. So what you are saying, that is not supported by the judgment of the Court of Appeal.
So, irrespective of the fact that they didn't consider B to J or whatever,
they
analyze all the evidence.
And
which is what you call the omnibus. So you agree with that as well?
No, I agree. You see, I began by saying something about the witness and the inability to tell us which witnesses are speaking to what charge. Because when you read the High Court, it's not exactly clear how she came to a conclusion on each of the counts that this were proven. That would give you her own assessment of the material record to say that even though it doesn't provide us particulars, I find those particulars in this evidence that was unchallenged on the record. That is why I'm convicting.
Okay, but there's a question. The AG wants to allow me. The AG wants to appeal. Yeah. So is the AG also a victim of the public sentiment, or AG is on all fours with Bafo? Because the AG has said in I think it was posted somewhere that he intends to file an appeal.
No, he said publicly that he agrees with the High Court and believes that the High Court is correct and is going to go ahead with an appeal. Now, at the time he said that, he himself said that he had glanced through.
He had glanced through the Court of Appeal,
the High Court's decision, the Court of Appeal's decision,
and had then directed the DPP based on glancing through.
Because this was during the press conference when the decision had just come out immediately, and that was his sentiment.
So that was his knee-jerk reaction.
That was the sentiment that he felt in those moments.
Like if based on what you've read in the Court of Appeal, will the AG be well advised to appeal?
We should go ahead. We should go ahead.
You think you go ahead?
Yeah. You know, like I said last week, somewhere else, it will help us. It will help prosecution. It will help in the teaching of criminal law in the law schools. Because what information should be contained in the charge sheet. That is adequate information to the accused person. What information? The Court of Appeal says this charge is defective because it contains little or no information. Okay? The Supreme Court will have opportunity to set the parameters, the standard, the information that should be contained. The Supreme Court will have the opportunity to validate or repeal or if you want set aside the judgment of the Court of Appeal if they believe that the High Court and settle this matter once and for all.
So it will be good for our jurisprudence
it will be good for our jurisprudence.
But we need to know arguments you make. But
I'm just coming. So for instance, Bafo read about the 500. In fact, I wrote somewhere on Facebook that I support you. Somehow in this conversation, the 500 million, I support Oliver. Oliver has said that he was going to initiate an action to recover the 500.
He's looking for the money.
He's looking for the money. He's going to follow the money. Somewhere in the conversation we are having now.
We've all forgotten about the money.
Who has the money?
We are thinking about whether somebody is punished, but we are not thinking about where the money is.
But what is factual is that 500,000 Ghana cedis left the coffers of Mas. After that,
and has not been accounted for. So that's why energy should be.
So you see why the prosecution did a poor job on that. The money on the records of Maslok, the money went to Obatampa. Obatampa says, and that's the narration of the prosecution, that the first accused person, demanded that money be returned to her in cash, even though they had elected to return the money by check. They said the only reason why they said they wanted to return the money by check, and this is for Oliver, is that after they took the money, the terms that the first accused person was giving them was so onerous. They couldn't 24%. I thought that in loan negotiations, you negotiate all the terms before you take the money. So and then secondly, they said the first accused person wrote them an acknowledgement letter. They were writing to them. So the original copy will be where?
With the first accused?
No.
With those who received it.
Those who received the money.
Did they produce it in court?
They didn't produce that. Thirdly, they said that, before they returned the money, they engaged in chats on WhatsApp with the first accused person. They didn't produce the chats.
So the assessors could not be backed by any evidence.
When they drove to give the money to the first accused person at Bachuna, there was no witness.
Nobody. No camera, nothing.
Nothing.
Let me
somehow in the conversation, that 500,000, we don't know where
has gotten lost.
So that's why I'm going to support
Oliver to look for the 500,000.
Because that's
so
our money.
what I want to do is give you a few minutes to wrap up this segment. So your final comment, because I have to do something
the
else.
judgment. Huh? I think that very respectfully, for want of a better word, I think you have rather misread the judgment, and I explain to you why.
Yes, tell me.
The grounds of appeal were found to be defective, with the exception of the omnibus ground.
Yes.
And the court evaluated the various charges which had not been set aside.
Yes.
And not the entirety of those that had been set aside.
No.
So you mean they evaluated 78 minus 34?
Exactly. And so if you misread it because
the
and that is why wait. You've interrupted me too much. And that
go on.
It makes me take too much time, very respectful.
Okay.
You see, and that is why I said you are not adverting yourself to the law. I read section 31, subsection 2 to you, and you all agree to the general position that when it is defective, it is generally not a ground or a basis to set it aside. And so that position holds. The subsequent position is to determine whether or not, in view of the defect, a miscarriage of justice has been occasioned. And I'm saying that this judgment did not do that. What the judgment proceeded to do, after setting aside the 34, it went ahead to evaluate the other charges. And so when you look at paragraph 68 of the judgment, this is what it says. It follows that count 36, 37, 38, 39, 40, 41, 40, charge right? Then it comes to say, for want of it, the convictions and sentences found upon those counts cannot stand. They are accordingly set aside.
So you mean that when you look at the list, is the 44 remaining?
That is what the court evaluated. Good. 2, in terms of stealing, that is why I said the court misdirected itself, and very respectfully, you are not adverting your mind to the rules of evidence. You are not adverting your mind to the rules of evidence. When you have the burden, right? You have the burden to produce evidence to discharge the burden. And
the burden, who has the burden to produce evidence?
I said, when you have the burden of proof, you have the burden to produce evidence.
I'm satisfied. I wanted you to complete
when
it.
You have the burden of proof, you have the burden to produce evidence to establish your case. Good. Now, the prosecution, in producing evidence, what did they do? You first have to appreciate that evidence is both oral and material. And so what did they do? They brought Obatampa, the very body that had said that, look, we have returned the money to her. That evidence was never challenged by the accused person. What is the effect of it in law? What is the effect of it under the rules of evidence? The effect of it is that they have admitted it. They have
by not challenging
the fact. At that point, it has been admitted. What did the court do in assailing this unchallenged evidence? The court relied on evidence which has not been tested. And this is where the rules on hearsay comes to play. When you fail to go into the witness box, right? In fact, your testimony, even if you have filed witness statement, right, and it is tendered as hearsay evidence. And unless the declarant of the hearsay is available to be cross-examined, that not much weight can be put on it.
Okay.
And so the court, by putting weight on that evidence, misdirected itself.
Okay.
That is the position.
And
so as far as the 500,000 series was concerned, right, the prosecution established it. Another case with the prosecution established, and that for me, that's the reason why I said that, Bernard, the court focused too much on what was not before it instead of what was before it. When you look at the money for sensitization, the court made reference to the witnesses that had come before the court. One of them was the auditor who have tendered an audit statement. The audit report, right, contained investigations, what do you call it? Engagements that he had done, including engagement with regional officers who have stated that the sensitization did not take place. The auditor's report and the auditor's testimony was never evaluated by the court. And so as we sit here, we don't know whether or not the auditor's report was even challenged by the accused person. In the absence of a challenge, that is also an admission.
We will leave it here because the judgment is available online and you can also read it and conclude. When we come back, we'll spend the rest of the time to look at the government's position paper on over 130 recommendations of the Constitution Review Committee. I'm going to ask each panelist to give me maybe their top 3 or 4 in terms of what the committee recommended and their views around the aspects government agreed or disagreed. This is the point of view. Stay with us.
Chef alone can command respect.
You haven't even checked the price.
Real men check quality first. Fear comes later.
Card, please. Wait.
What again?
Check the amount first. Madam, it's correct. Please show it to us. Hey!
25,000!
Oh, it's a mistake.
My sister, why?
Oh,
am I buying the shop too?
It's a mistake. I'm sorry.
My spirit almost left my body just now.
Daddy, please check.
Good. I feel you do Mizima.
Network issue. Please give me the card so I'll go and check inside.
No, the card stays with him.
Always confirm the amount before tapping or entering your PIN, and never allow your card out of your sight. Spot the fraud. Stop the fraud.
This message is brought to you by the Ghana Association of Banks.
Welcome to a place where everyday living is reimagined, where space, movement, and community come together effortlessly. With thoughtfully designed spaces, modern facilities, and everything you need within reach. You don't just live here, you feel safe, comfortable, and at ease. Step inside Eden Heights and discover spaces crafted for comfort, style, and everyday living. And just when it feels right, you will know. Because this isn't just about finding a house, it's about stepping into a better way of living. Eden Heights, the height of modern living. Book a private viewing today.
Welcome back. So this segment now focuses on the point of view, on the government's position paper on the final recommendation of the Constitution Review Committee. Don't forget, within this decade and a half, this is the 3rd attempt. The first attempt was under President Mills when the 1,000-page report was produced by the Professor Fiajo Committee. Now, one of my panel members was a member of the team that worked under the hand of Raymond Atuguba, Executive Secretary. So Oliver is familiar with that work. Under the MPP and Nana Akufo-Addo as well, Osechi Mensah Bonsu's group did do some work with the likes of Clara Kasati and co, also on Constitution Review. The 8th Constitution Committee presented their report in December, and the government has presented a position paper. We have a summary here of about 60 recommendations of the committee accepted or supported by the government with some modifications, 60 outrightly rejected, providing statutory alternatives or different pathways, and then about 10 which we are told are mixed or partly accepted. This work was done by a lawyer. Oliver, since you have so much to say about this, let me start with you here. I interviewed you when Kwesi Prempeh's group finished their work, all right? So this 60-10-60 summary, if it is correct, is it surprising to you? Are you happy with it that they've spent so much time producing 500 pages and the government has dismissed half of it and accepted half? I mean, how?
Yes, I mean, it's a difficult thing to think about, particularly I think that on the my biggest surprise is on the issues where the government is proposing different alternatives.
Yeah.
Because it seems to me that the committee met with so many people, including members of government,
Yeah.
that some of the ideas that we are seeing here, we are seeing them for the first time, and were not presented to the committee to consider as part of government's thinking on this. So we haven't tested them at any point. They've just come in at the latter stage, and I'm kind of wondering why some of these were not shared with the committee to also express this view and
incorporate in that
incorporate
report.
at least in that report. So that's kind of what I find a bit perhaps strange. The other areas where I think the government is decidedly a little more progressive than the committee, particularly on the question of the Attorney General.
Okay.
So the government now has removed the Attorney General from cabinet. It's no longer a minister. And that's something which the committee did not get into, which I think it answers, it is the government's attempt to answer the OSP question differently. Because one of the ways in which we have talked about the OSP's office is the concern that because the Attorney General sits in cabinet, is not able to prosecute his colleagues. And so they have then brought this in as another mechanism to deal with that same problem. So I'm surprised by that. One of the things that we had been campaigning Democracy Hub for a long time is the Citizens Initiative that the committee recommended and the government accepted. So that for the first time now, citizens can propose constitutional amendments, rally votes, signatures from persons of voting age, and then that will be tabled and considered in Parliament. I think that's a useful addition. There are other areas, of course, which are regressive.
From the government side.
From the government side, in particular, there are certain suggestions which the government operated without the overriding theory that was animating the committee. For instance, the committee suggested that we take away Shraj's anti-corruption mandate, which the government accepts. But their rationale was the proposal to then put that into the Anti-Corruption and Ethics Commission, because they wanted to centralize the powers. The government refuses that. So you have then depressed the anti-corruption obligations and they're not accounted for where.
So it's like a sleight of hand.
You
accepted the offer by having
given
back
them
what
they were trying to rechannel it.
That's
it towards. There's I was a big fan of the Independent Securities Services Oversight Authority, because we are. I mean, I think the Upper East chapter of the Ghana Bar Association has come on record to accuse the police of extrajudicial killings. The questions of extrajudicial killings have been, covered extensively by the Fourth Estate, and I thought that there are many such commissions in Jamaica and other places which are looking at whenever force is used by the security services, whether somebody is providing independent oversight, not left to the institutions themselves, that the government rejects and uses language generally that, we have the National Security Council generally without addressing, those issues as well. But I think the most important thing for me, my biggest concern, is that the government ought not to have a final word on all of this. That I think that different groups, organized labor, must also come out with position papers, and we must then re-understand the mandate of what the implementation committee is going to be. In the Attorney General's presentation, we were told that the implementation committee was just going to draft amendment bills. Well, that's if it's only a draftsman's job, then all the horse trading, all the political arrangements that we have to be able to come to consensus around these things seem to have already been settled in a way in which I don't think is necessarily a fair approach.
So materially, in your case, they did the white paper because it was
yes, I think that the government has taken to this as a white paper, and I've written on this that my understanding of a position paper was the government should state its views. We have looked at what the committee is proposing. However, we have a different opinion.
But when you say they've called it a position paper, but then it's a white paper masquerading as a position paper,
and it takes the same tone. We accept, we reject, we propose, we.
Okay, Alaji, there are 130 or so recommendations. We don't have time to go through all. What are your top 2 or 3 things that caught your attention?
Well, I think that straight out the dual citizenship. I've always argued that we shouldn't limit the pool of human resource available to us. And so people who are outside and are Ghanaians by birth, who want to come and serve the country have the citizenship of another country should not be prevented from serving. And I'm happy.
They shouldn't renounce their other citizens.
Why should they?
Well, because
we have got judges, Ghanaian judge who went and sat somewhere as a chief justice. That country do not accuse him of spying or doing something which was
so apart from the presidency
and the vice president.
but I think the Council of State rejected a dual citizenship bill. They didn't.
What I'm saying is that it's the Council of State. What I'm saying is that I rejected this. I said this when we were passing the OSP bill, and I said people in the diaspora who already know how these financial crimes are committed, who know how to follow corruption, and who are Ghanaians but have taken citizenship by convenience, should be allowed to come and help us to fight corruption. It was rejected.
So
we
limit it to by convenience, not by. I understand what you're saying.
Yeah.
So that's number one.
That's number one. I also think that the setting up an independent emoluments committee, and that is your distance to deal with this Article 71 office holders, so that we don't.
The president cannot appoint someone to determine his salary.
We don't create.
The independent person must determine everybody's salary.
We don't create that problem between Article 70 of the Constitution, which says everybody should be treated equally, equality before the law, with Article 71, which appears to treat people differently by status. Okay, so I think that is good. So everybody comes under one umbrella. And then the relativities. I don't agree to the 5-year extension. No one has told me why we need 5 years for a president. The only time it came was when President Kufuor, in his last State of the Nation, said that it appears that 4 years too short, because 1 year is used for setting up government. The last year is used for campaign.
Who forced them to campaign?
No, what I'm saying is that it's efficiency. I mean, no one is talking about efficiency. I mean, is it possible to do this in 4 years? And government being efficient? And until someone convinces me that it will be more efficient if we have 5 years, I will not go by it. And it's consequential. So I don't support Parliament 5 years. I don't support MMDCs. I also do not support government's position on the election of MMDCs. I think that it's a misframing of the issue. It's not executive accountability that Ghanaians are looking for. They're looking for accountability at the lower level. Okay? That people who are elected at the lower level to be their DCs must be directly accountable to the people. Okay? And not somewhere else. And
so for the president to say
I'm going to nominate 5, the PSC will prune it down to 3, and then
it's similar to what was in your work. So it's not so they just lifted the old one and put it
no, so we have moved. That's why they have said they should look at the old one. We have moved.
Who writes these position papers? Is it one person or a group?
I understand the cabinet deliberated over an original draft that I think came from the Minister of Justice.
So this is like the view of cabinet in totality. Interesting. So those are the ones that caught your attention.
There are many.
There are about 20. They said 24.
There are many, but I think that
elected MPs to complement the 276 for some proportional representation.
So that one will have to come for discussion. How is it going to be done? Is it going to be done on the basis of numerical strength in Parliament, like committees are allocated? Okay, based on numerical strength, or is there going to be another elective mechanism within the parties for people to take their positions?
What caught your attention in these matters? Which committee are you on?
Subsidiary legislation, constitutional and legal affairs.
So the two relevant committees.
Yes,
very good.
So the point is this: I want to make this initial point, Bernard. No matter how many times you amend your constitution, unless your value system as a country is intact, it's an exercise in futility.
Can you repeat that? I like it.
No matter how many times you amend your constitution, unless your value system is intact, it's an exercise in futility.
I like this.
Look at the English. They have an unwritten constitution. Nobody would tell you that in England, when you lie on your CV as a public officer, you must resign. There's no law. But because of the value system, you will resign. It is not the constitution that results in this. It's not the constitution that would let somebody steal. Politicians who protect the person and so on and so forth. It's the value system.
Correct.
Our value system has broken down as a country completely. All facets of it. And so you can amend the constitution, you can somersault it. Look, somebody, whatever you want to achieve, somebody by a stroke of pen will sit at the Supreme Court and tell you that that is not the original intent of the framers of the constitution. Because the value system has broken down. And so we must begin to retrace where we lost it and fix it. Otherwise, no matter the amendments we make, we will not achieve it. Look, until the Public Procurement Act, for instance, was passed, we're using the Crown Agency system of procurement. That was not as rigorous as our public procurement system. The moment we passed our public procurement system and we said, oh, single sourcing is a rare occurrence, right? People have found a way to do single sourcing in this country. Ghanaians are very smart. Let me tell you, a Nigerian colleague once told me that in Nigeria, somebody can dip his hands into public coffers and boldly, brazenly take money. Ghana, they won't do that. There will be paper trail. And so it will be very difficult for you to catch the person. That is the difference between Ghanaians and Nigerians. So our problem is the breaking down of our value system.
It's not a lack of
relevant
laws. But the idea is that we need to move from an electoral democracy to what do you call it, developmental.
We agree.
And all of those nice
It is
things.
not achieved necessarily by the Constitution.
Interesting.
No law can tell you that. Look, it takes a lot for you to say that, look, this project, when I came to meet it, it's taxpayers' money. We borrowed money to develop it. And therefore, if I don't finish it, we are going to spend more paying for the loan and more completing it. This one...
It's not a legal issue. It's a value systems issue.
It's a value systems issue.
Interesting.
Do you understand? The moment, even when you pass a law, they'll find a way around it. And so, in my humble view, we must fix our value system. Our value system has really broken down.
Can't you use law to do that?
What laws don't we have? Look at the anti-corruption agencies.
But the multiplicity of laws does not necessarily mean the appropriateness of laws.
So we have appropriate laws. As for laws, we have appropriate laws. It is, you see, our value system has broken down. We must fix it. That said, I agree with Mr. Inusa Fuseni. The 5 years, I don't agree, and I've made extensive presentation on this. I don't agree. It's 4 years. If you do well, we give you additional 4 years. Let's focus on building our value system. Let's focus on building institutions. Whoever comes in, the sense of loyalty, the sense of patriotism should guide the person to do what is right by continuing from where you left off. However be it, even in your 5th year, you are going to start projects that you may not finish. In your 5th year, you may take a loan that you may not finish paying. Somebody will have to come and, complete with the repayment. So in the 5th year, there are so many things that you will do that will not.
So 1 extra year doesn't change.
It doesn't change anything. When I look at the reasoning behind it, very respectfully, it's the more reason why I'm against it. I'll tell you why. The president alludes to the use of 1 year to complete appointments and so on and so forth. It's because we have not been serious in our politics. Politics is a serious business, and I know you will agree with me. Why is it that we wait for 6 months to the elections, then we put out our manifesto? Our alternative should be a recurring, what do you call it? We should keep on, arguing and putting out our alternatives in the course of the government's tenure.
It shouldn't be a ceremony of 6 months to election.
Exactly. For instance, the public tribunal bill was put out. Dr. Mahmoud Bawumia spoke out and gave the MPP's alternative.
So you won't wait for manifesto
We won't wait for manifesto's time. Our alternative is to continue with the course that we were building, right? That's our alternative. And to invest more in technology instead of paying more judges, more tribunal panels.
Fair enough.
Right? That is what happens in places like the United Kingdom. And so when it is the Prime Minister's question time, and the leader of the opposition comes toe-to-toe with the Prime Minister, when she criticizes the Prime Minister, she's also putting out her alternatives. But we don't put out alternatives. 2, the appointment you are referring to, who are your key spokespersons for various sectors? In the year 2000, when President Kofi, in the year from 1997 to 2000, when MPP was in opposition, Bernard, we all knew who at some point to become a minister in President Kofi's government.
It was clear.
It was clear. And following President Kufuor's appointment, all those people became ministers. Today, it's not like that. Mr. Yunus Afuseni may speak for the NDC on lands and natural resources. The moment the president assumes office, he's looking for, you see, the people behind him are looking for people they can control. So they are not interested in Mr. Yunus Afuseni because Mr.
Who says they can't control him?
Because
no, can you be controlled?
It's just an assumption. Because they think that they cannot control Mr. Yunus Afuseni. My brother was a very fantastic advocate when the NDC was in opposition, disrupting a lot of stuff, right, just to benefit the NDC.
No, don't go there.
When they came into power, they know that they cannot control him, so they will not give him a position. Are you getting me?
He wants it.
So
who says he wants
There's a lot of assumptions in there.
But let me take two final comments. But your points are fantastic. Two things. When he said his values and not laws, you were twitching because I know you, even though you believe that, you still think using law we can change behavior. That's why you were twitching in your seat, correct?
Yeah, I mean, I think more generally to the point that the roadmap for how we do this, because I don't want it to become a punchline for which obstructs how we rethink some of the tools that we have available to us. That I haven't seen any government, whether it's in opposition or in government, present a roadmap to fixing the national value system. So unless it becomes more than the generic, right? Or that we need to pray more, or things like that.
You need something specific. So even though you agree what he's saying, the constitution reform is more tangible.
That's my thing. And I remember the conversation, for instance, when we were having this conversation about fix the country and fix yourself. I always said that I didn't doubt that it was a pathway. But how do we do it? Okay. How are you presenting as the pathway to? So I don't think that we have figured that out. And I completely agree. This morning I was listening to conversation about I think it was the BC. And we're talking about, some of the cheating that goes on in the BC and things like that. And I'm just kind of wondering, it seems like there's no area of national life which is spared from the rot. So I'm interested.
You mentioned the BC. Let me share something quickly with you. So a gentleman approaches me in my constituency that I should assist his ward to get enrolled in the security agencies. So I took the results of the ward. Then I said, but Daddy, why are they pa? So why don't we send her to the university? Or see, they won't to me university. That is to me great, great now. When you are now very beautiful. Great. To be university hall.
I see.
What I say? He cannot justify the grades at the university.
But he can justify it for the security agencies.
Our system is broken.
I'll give you the last word. You are the most experienced man on the
Constitution is full of values. For Constitution, that's why I was looking for Professor Mwezu.
Yeah.
That's why I was looking for his name. The Constitution is a reflection of the values that you stand for. So that is why the Constitution is a product of the people. You cite the UK example. Their Constitution has developed over a long period of time. At the time when writing was not even the invoke, they had somehow decided that this is how they want to rule their country. And that has concretized. Even now, you can't say that there's no written because there are aspects of the UK system that are written. The Magna Carta is a case in point. It's written down. But our Constitution, read the preamble. Every provision of the Constitution speaks to the values that we stand for.
And the values are not broken?
So, no, if we say our values, if we say they are broken, it's that we must fix it. And a constitutional review.
So the Constitution could be the roadmap
to
fixing
it.
Society and
but
also our
values.
Our
Constitution, from the preamble, talks about, look at 296. Discretion, use of discretion, is the values of democratic principles, is the values that we stand for. And that we shouldn't give somebody power without checks.
And then 296 was interpreted.
What I'm saying that no, I'm not talking about interpretation. I'm saying
in certain instances, in the absence of a regulation, right?
Well, what I'm just telling you, I'm
So
telling
it's the
you.
constitution in action
So
that is more important than just the written text.
Yes,
the way
it's
it is used.
It's a constitution in action.
You need values to
You can't-
guide
you
the
can't draft a constitution
in action.
You can't draft.
Maybe
you
we
can't-
need a committee here to set up a values roadmap.
Bernard,
Because Bernard, you see,
Bernard,
No, we know a
you
lot
can't
of
draft
I
a
know,
constitution
but Bernard, the
without
show has
standing
ended.
for values.
The show has ended.
The show has
That is what
ended.
animates
I like
the
to thank
constitution.
I like to thank lawyer Nana Ejebafwe, MP for Menchia South, Oliver Bakavomawo, he's from Democracy Hub. He has a big title there. I don't remember the title. And then we have former MP for Tamale Central and former Minister for Lands and Natural Resources, Alhaji Inusa Hussaini. Thanks for watching. We'll see you next time. Bye-bye.
Every day, across Ghana, stories unfold. Stories of hope, struggle, courage, and progress. At Channel 1 TV, we tell your story with truth and heart, giving voice to the people, holding power to account, and empowering change that moves our nation forward. Channel 1 TV, telling your story.